Can you guys hear me?
Yes, Your Honor.
All right. Is everyone ready to go? We have both sides here.
Medallion's here, Your Honor.
I'm sorry?
Medallion is here, Your Honor.
Do we have our new court reporter here? I don't see her. Is Miss Varela here? Is Brenda Varela here? There she is. Okay. Miss Varela, are you there? Miss Varela, are you there? She's our new court reporter. I understand you guys want dailies for this.
Yes, Your Honor.
Okay. And Miss Varela, can you hear me?
Hello, Judge. Yes, I can hear you.
Okay.
If I could just get like 1 minute, I'll be ready to go on the record, if that's okay.
Okay. Let me know when you're ready. Are you ready, Miss Varela? Let me know when you're ready.
Just 1 second. I'm sorry. Okay, I'm ready to go.
All right, let's go ahead and proceed. If the witness can go ahead and state your name for the record. Go ahead.
Scott Wishaw.
Okay.
I'll pull that mic a little closer.
All right, you may proceed.
Before I proceed, I failed to offer plaintiff's exhibit 31. which was the email cover with the term sheet, which we would now offer.
Let me double check that. Okay, any objection to plaintiff 31?
Yes, Your Honor, that's parole evidence. It's a term sheet document.
Yeah, that really did not seem to qualify as an exception under. Yeah, I'm going to go ahead and sustain that objection. Plaintiff 31 is not admitted.
All right, let's
Okay.
look at transportation services agreement itself, which is marked as plaintiff's exhibit 1 and has already been entered into evidence. Mr. Wishoff, is this the terminal services agreement that you negotiated with Medallion?
This is the transportation
I'm sorry.
services agreement. Yes.
Yeah, transportation services agreement. I'm sorry. And it's dated?
July 3rd, 2019.
All right. And this deals with ARM's use of the commitments with respect to the pipeline capacity on the Epic pipeline.
Yes, it does.
And it is, we look at the first paragraph on page numbered 1, which is 3 pages in. It says that this is a contract between Medallion Pipeline Company as carrier and ARM Energy Management as shipper. Do you see that?
Yes.
Is Epic a party to this contract?
No, they are not.
Did you ever have any, or did ARM ever have any contract with Epic regarding transportation on this pipeline?
No, we did not.
All right, let's look on page numbered 6. That's page numbered 4. Let's go to page numbered 6. And at the top, there's a definition of a tariff. Do you see that?
Yes.
And it says the then effective local and proportional rules and regulations tariffs filed and maintained with FERC that sets forth the terms for crude petroleum transportation services on Medallion Pipeline as may be supplemented and amended from time to time, and then effective local and proportional rules and charges tariffs filed and maintained for FERC that sets forth the rates and charges applicable to crude petroleum transportation services on the Medallion Pipeline as may be supplemented and amended from time to time. Do you see that?
Yes.
And if we look on the page numbered 3, there's a definition of an Epic tariff. You see that? Numbered 3. See that down at the bottom?
Yes.
So there's both an Epic tariff and a Medallion tariff that's defined in this contract.
Yes.
And if we look on the page numbered 6, which is probably the 9th page. That's 7. There's an Article 2 that has the carrier obligations. Do you see that?
Yes.
And it says provision of services subject to the provisions of this agreement. Carrier shall provide committed firm service for the committed volume for the transportation of crude petroleum from the origin points to the destination points in accordance with and subject to the tariff. Would that be the Epic tariff or the Medallion tariff?
I believe that's the Medallion tariff.
Yeah. Which is incorporated herein by reference and constitutes part of this agreement expressly including provisions in the tariff relating to charges and rules and regulations, et cetera. Okay. So it incorporates you incorporated the Medallion tariff. And if we look to 204, it says operation. down at the bottom of that page. During the term, carrier will transport crude petroleum in accordance with the terms of this agreement and the tariff. And is that the Epic tariff or the Medallion tariff?
The Medallion tariff.
And if we look on page numbered 5, there's a definition of services. Oh, 3 definitions up. Means transportation of crude petroleum for shipper's account on carrier system utilizing the least capacity from the origin points to the destination points specified in the shipper's nomination as set forth in this agreement and the tariff. And again, is that the Epic tariff or the Medallion tariff?
Medallion tariff.
All right. Now, if we look at the Medallion tariff, which is Defendant's Exhibit 8, and I believe has been pre-admitted. Is this the Medallion tariff?
Yes.
And if we look at page 7 of 19, those page numbers are at the top, Brian. 7 of 19. There's a commodities description and measurement provision. Do you see that?
Yes.
And there's a rule number 3, crude petroleum quality and specifications and restrictions. Do you see that?
Yes.
And if we go to the next page, there's an underlined section. It says, with respect to transportation utilizing the least capacity, and I'll represent to you in the court, everybody can check, but the least capacity refers to the capacity that Medallion has leased on the Epic pipeline. You understand that?
Yes.
With respect to transportation utilizing the least capacity, crude petroleum shall be accepted for transportation under Epic's Permian Common Stream 1 and Permian Common Stream 2 from Epic origin points and other than excluded origin points pursuant to the quality specifications of the Epic rules and regulations tariff. You see that?
Yes.
And what was your understanding of the Common Stream 2 under the Epic tariff?
Common Stream 2 was WTI light.
Now, during opening, Mr. Patterson showed the court a tariff which has been marked as Exhibit 9, Defendant's Exhibit 9, and noted for the court that that tariff in Exhibit 9, which says Epic Crude Pipeline Rules and Regulations Governing the Interstate Transportation by Pipeline, and it was effective July 1, 2019 through August, or excuse me, it was issued July 1, 2019, and it was effective August 1, 2019. And Mr. Patterson pointed out to the court that there was no Common Stream 1 in this, or excuse me, Common Stream 2 specified in this tariff. You see that? Or do you understand that?
Yes.
What is this tariff, sir?
This is the interim Epic tariff that was in place before they went to full service when our contract started.
Now, just to be clear, what was the pipeline that you were leasing capacity on through Medallion?
The 30-inch pipeline.
Does this tariff apply to the 30-inch pipeline?
No, this was when they were on the 24-inch NGL pipeline.
Okay, well, let's unpack that a little bit. It says for interim service only. Did ARM contract for interim service?
No, we did not.
Did on what pipeline was that interim service provided?
It was on the 24-inch NGL pipeline.
What is an NGL pipeline?
Natural gas liquids pipeline.
Does this tariff have anything to do with the contract between ARM and Medallion?
No, it does not.
Let's look at the contract that does have something to do with or the tariff that does have something to do with our contract. Let's look at Plaintiff's Exhibit 4. Can you tell the court what Plaintiff's Exhibit 4 is?
It is the EPIC crude pipeline tariff beginning April 1 of 2020.
And what does this have to do with your contract?
This is when our contract started.
And does this tariff apply to the interim NGL pipeline that was utilized by EPIC or the new 30-inch pipeline that you were going to ship on?
The 30-inch pipeline.
And in this tariff, if you could look at page 33 of 35. What is this?
This is the carrier product specification.
And does that include WTL?
It does, as Common Stream 1 WTI and Common Stream 2 WTL.
Was this consistent with your understanding of the crude that you were negotiating and agreeing you would have the right to ship on the EPIC pipeline through Medallion?
Yes.
Now, we can return to Exhibit 1, which is the agreement, the Transportation Services Agreement. During opening, Mr. Patterson focused the court's attention on the definition of committed firm service on page 3 of the contract. You see that? You'll get there. Page number 3. I'll have better page numbers for you later. All right. You see about 4 or 5 definitions down. It says committed firm service.
Yes.
And committed firm service means priority capacity that is equivalent to the highest level of service offered or provided by EPIC Pipeline. Do you see that?
Yes.
Does that have anything to do with the specifications of or grades of crude that EPIC is shipping on its pipeline?
No, this refers to the level of service you are receiving.
Okay, and what can you describe the different levels of services that you can get from a pipeline?
Yes, you can get firm service, which means that outside of a force majeure, you are to receive that service. You can receive interruptible service, which means you can get cut for any reason at any time. And there does not need to be a force majeure.
And if we could, sorry to jump around, but if we could go back to the EPIC tariff that actually applies to this contract, if we could, that's Exhibit 4, Plaintiff's Exhibit 4, and if we could look at page 6 of 35. Do you see where it says there's a definition of firm service?
Yes.
It says firm service means the type of premium service provided to committed shippers. Under firm service, committed shippers pay premium committed rates relative to uncommitted shippers during prorationing months in exchange for not being subject to proration on the lesser of their monthly nominated volumes or MDQ. What does that basically mean?
That means if you're paying for the firm service, that they will not prorate you. And they will prorate the interruptible services.
And were you getting firm service or interruptible service under your agreement with Medallion?
Firm service.
All right, I was going to bounce around in the Transportation Services Agreement to try to establish what the MDQ was, the minimum daily quantities, but could you just tell the court what quantities ARM agreed it would ship as a minimum daily quantity and that Medallion agreed to ship?
Yeah, so the total would be 27,778 barrels per day.
And monthly, what does that add up to?
Depending on the days of the month, that 830,000 to 861,000.
All right, and if we look at Exhibit 1 again on page numbered 7, Brian? Where is that? 2.05, one of the carrier obligations in 2.05, it says carrier shall be responsible for maintaining, I'm having trouble seeing that on this. Providing and maintaining all required line fill. Now, we talked about that in connection with the initial offer. What was the significance of that to you?
The shipper, which would be AEM in this case, would not be responsible for the line fill, which was important to us because that is crude oil that sits in the line, in this case for 5 years, that we can't sell. So it would have tied up our capital for 5 years.
And in opening, Mr. Patterson said something about you required 100,000 barrels to ship a batch under this contract. Who is responsible for filling that line?
The carrier.
And that would be?
Medallion.
Was that ARM's responsibility at all?
It was not.
All right, let's switch gears now and jump to the terminal services agreement, which is Exhibit 2. Plaintiff's Exhibit 2, and I believe has been pre-admitted.
It has.
Is this the terminal services agreement?
Yes, it is.
And is Epic a party to this contract?
No, it is not.
Did you ever have any contract with Epic regarding use of the terminal?
No, we did not.
Article 3 at page 7, page numbered 7. Sets forth the services that Medallion would be providing. And it says from the respective commencement date for the initial terminal and new terminal as applicable through the remainder of the term, Medallion shall provide or cause to be provided the following services, together the services on a firm basis. And it says receipt of customers' crude petroleum delivered to the receipt point. Delivery of crude petroleum to vessels at the initial terminal at loading rates of at least 20,000 barrels per hour, and delivery of crude petroleum to vessels at the new terminal at loading rates of at least 40,000 barrels per hour. You see that?
Yes.
And is 40,000 barrels per hour the loading rate for a Suezmax or an Aframax?
Suezmax.
And is there any qualification there that this is subject to some time limit or delay?
No, it is not.
And then marine loading. It says for each, then on the next page, 3.4, and this is the language we've been talking about. For each month after the initial terminal commencement date, customers shall be entitled to nominate on a firm basis up to one marine vessel, the firm loading vessel, for the marine loading of crude petroleum, either at the initial terminal or the new terminal, subject to the occurrence of the commencement date for the new terminal, each with a capacity of not more than 1 million barrels of crude petroleum. From a commercial standpoint, as the negotiator of this agreement, what did you understand?
That we had the ability once every month to load a vessel capacity of our choosing up to 1 million barrels.
Did you have to load up to 1 million, or did you have to load 1 million barrels?
No, we did not.
That was an option that you had?
It was our option, yes.
And we talked earlier about the benefit of a Suezmax versus a smaller vessel. And again, what were those benefits?
1 million barrels is a higher efficiency, moving more barrels to the same locations on the water. And we needed 830 to 860,000 to match our flows on the pipeline.
All right, so you got the terminal services agreement and you've got the Transportation Services Agreement. In the presentation that you made, or that was made to your investment committee, there was mention of Gunvar and Vitol as potential partners. Was anything ever worked out with them?
Not with Gunvor or Vitol.
Did you find a partner like Gunvar or Vitol?
Yes,
And who was that?
Glencore.
And how did Glencore come into the picture?
Josh Sarman was talking to these international traders about many things. And as he was talking about these capabilities that we had and the partner we were looking for, we narrowed it down to several customers, and it ended up being Glencore.
What business was Glencore in?
That they are an international trader of multiple commodities, especially waterborne crude oil.
Are you talking?
I'm sorry, I was, my lawyer here told me I should actually look at something in the page 1 of the Terminal Services Agreement before we get into more detail on Glencore. Oh, okay. There is on the first page, page numbered 1 of the Terminal Services Agreement. The first whereas clause, it says, whereas Epic Crude Terminal Company owns and operates a crude terminal facility at Robstown, Texas, with throughput capacity of 400,000 barrels of crude petroleum per day, and that's defined as the initial terminal, and will construct, own, and operate a crude oil terminal facility located adjacent to the initial terminal with storage capacity of 4,700,000 barrels of crude today and throughput capacity of 700,000 barrels of crude petroleum per day, and that's defined as the new terminal. So when we were looking at the contract and there was a reference to the new terminal and the initial terminal, was it your understanding that that's what that's referring to?
Yes.
All right. Let's look at the deal that you did with Glencore. First of all, if you could look at Plaintiff's Exhibit 3. And I believe this was pre-admitted. Can you tell us what this is?
This is the master crude oil agreement between AEM and Glencore.
And then there were assignments of the rights and obligations under the Terminal Services Agreement and the Transportation Services Agreement, and I believe those were marked as Plaintiff's Exhibit 57 and 58. You recall that?
Yes.
All right. And were those assignments done pursuant to this master crude oil agreement?
Yes.
All right. We could get into the weeds on the various provisions of this, but can you just give us a commercial overview of how the arrangement with Glencore worked?
Glencore took assignment of the transportation and the terminal agreement. Glencore became the manager of that capacity. Glencore did not participate in the value from the greater Permian Basin to the dock. ARM, AEM were the responsibility of that $1.50. There was a provision for credit support. Obviously, Glencore is as we said, is a large international trading company. Glencore was going to provide their credit and their capabilities to fill that pipeline. And then as the barrel passed to the water, there are provisions that cover the cost, insurance, vessel, et cetera. And when those costs were, once those costs were covered, anything above and beyond, 40% would go to AEM and 60% would go to Glencore.
All right. So just to be clear, there is the transportation from West Texas to Corpus Christi under the Transportation Services Agreement where ARM agreed to pay $1.50.
Correct.
And to the extent that there was a loss on that, who bore that risk?
AEM,
And to the extent there was a profit on that transportation, who bore that risk?
AEM,
Or who profited?
AEM profited on that portion.
Okay. Was Glencore in any way exposed to the risk or the opportunities presented by that segment of transportation?
No, they were not.
Okay, I'm not clear what you just said. Did you say that were they exposed to the risk or I wasn't sure what you said after risks.
Or opportunity. I'm sorry, Your Honor.
So they didn't get, I thought they got 60% of the profits. Is that wrong?
Is that on the water?
60% of the profits once the barrel got to the water. So
Okay.
the two pieces, the transportation capacity, AEM bore the risk and reward. And then when the barrel got to the water and they shipped it on a vessel, then it was 60-40 after costs were covered.
For example, if the oil is put on a vessel and shipped, well, put on a vessel, there's a price in Corpus Christi, and then there's a price at whatever foreign location it may be shipped to. To the extent there was a profit on that movement of the oil, that was shared 60-40.
That's correct.
Is that clear, Your Honor? Or?
Yeah.
Okay. Now, did under this arrangement, who was actually facing Medallion?
Glencore.
And to the extent the 150 was it paid directly by ARM to Medallion?
No, ARM would reimburse Glencore. Glencore would pay Medallion.
All right, and it was, how was it anticipated when you guys entered into this deal with Glencore that crude would be sourced to put onto this pipeline capacity on EPIC in West Texas?
We have the credit provision that I mentioned where when we needed large wholesale transactions in the marketplace, Glencore would buy those volumes to put in the pipeline and ultimately ship. And then it was designed that AEM, over time, we would take our producer contacts and hopefully add to the capabilities of our WTI and WTL.
So this agreement with Glencore was signed or is dated December 2019?
Yes,
So that was some months after you'd actually signed the two agreements with Medallion?
correct.
At the time this was signed, were there any limitations on where ARM could source crude?
No. Oh, yes. So sorry. We did have limitations in December of 19. Salt Creek being controlled by Aries, we had an AMI that we were not to transact or interfere with Salt Creek's business.
And what is an AMI?
An area of mutual interest,
And what area did that cover?
the Salt Creek system.
So just to be clear, could ARM source crude for this Glencore Medallion deal in that Salt Creek area?
We were not supposed to pursue customers on that Salt Creek system.
All right. And just to set the stage, who did you deal with primarily at Glencore?
Guy Freshwater.
Now, there's reference in both the Transportation Services Agreement and the Terminal Services Agreement to a commencement date. What was the commencement date?
April 1 of 2020.
And what triggered the commencement date?
The first flow on the 30-inch pipeline.
And that was the pipeline that you secured capacity on through Medallion.
Yes.
Now, we saw in some of the early documents that there was a discussion about the terminals being ready in June of 2020.
Yes.
All right, I want to show you, this is post-contracting. Exhibit 190, Defendants Exhibit 194. And can you tell us what this is?
This is looks like a shipper meeting presentation by Epic.
All right, and it's an email dated November 20, 2019 from Veronica Lewand. Did I say that right?
I believe so.
At Epic. What was her position at Epic?
She was the head of scheduling, which manages the operations of the pipeline, crude oil in, crude oil out.
And just to step back, as far as scheduling, what is the actual process for getting a load of crude onto the pipeline?
You submit your nominations to the pipe, which is your schedule of origin points, so where the crude is going to come in, and your destination points, which is where the crude is going to go out. And you tell the schedulers what the quality and what the volume will be.
And under your arrangement with Glencore, who would handle the scheduling?
Glencore.
All right, but in any event, we've got this email from Veronica Lewand to you and Mr. Sarman, and the subject is Epic Shipper Group Full Service Scheduling Operations Meeting. Do you see that?
Yes.
And she says, "All please find attached presentation. We request that you please keep this confidential." You see that?
Yes.
And then what's attached?
I believe that's the presentation.
And if we look at the page of the presentation numbered 8, numbered 8, it's the page right after this one. All right, this is, looks like a presentation we saw earlier, right?
Yes.
And it refers to the origin points of Orla, Crane, and Wink, which I believe you said were WTL origin points.
Yes.
And it talks about the operational crude storage that would include WTL. Do you see that?
Yes.
And then the Epic waterborne terminal, it's now saying Aframax, that the initial terminal will be Aframax capable private dock in Q4 2019. And then the Epic new build dock will be Suezmax capable dock, 1 million barrels of Q3 or Q4 2020. You see that?
Yes.
To the extent that the initial terminal is now designated an Aframax and the Suezmax terminal is being delayed to Q3 or Q4 of 2020, did ARM raise any complaints with Medallion at this time about those changes?
We would have been talking to Mike Lassman about this. We were given assurances that the dock was coming online, and we were tolerant of delays. This was a big project. There's a lot going on, and we were willing to continue with the deal.
All right, and the commencement date you said was April 1, 2020.
Yes.
And if you could take a look at, well, let me make sure I offer Defendants Exhibit 194.
Any objection?
No objection.
No objection, okay. 194 is admitted.
All right, let's look at Plaintiff's Exhibit 70. Can you tell us what this is?
This was a notice from Medallion that service was to commence. This is the full service commencement email effective April 1, 2020.
All right, so that's April Fool's Day 2020, right? That it's commencement date, right?
Correct.
Okay, 70's been pre-admitted, so it's fine. All right, let's look at plaintiff's exhibit 77. And this is a series of emails 3 days after the service commencement date, right?
Yes.
And let's look at the first email on the last page. On the last page. Oh, second to last page. 359. It's the second page of the document. If you just turn the page. All right, this is Veronica Lewand again, and it's dated April 3, 2020, and it's to Mr. Sarman and I guess, and you. And she writes, due to changed circumstances, Epic Crude Pipeline no longer intends to offer WTL service under Permian and Eagle Ford Common Stream numbers 2. Instead of canceling such service, Epic is asking all of its committed shippers to forego submitting nominations under those common streams until further notice. Do you see that?
Yes.
Was that the first time you were told that Epic would not accept WTL service?
Yes.
And what did you do?
We sent that to Mike Glassman to understand our contract with Medallion and where we were.
All right. And if we look at the first page of this document, Exhibit 77, we see at the bottom there's your email to Mr. Lassman on April 7, 2020.
Yes.
And you forwarded Ms. Lewin's email.
Yes.
You said, I wanted to check if you received the below and if you had any thoughts about it. See that?
Yes.
And Mr. Lassman responded, I've not received this. Thanks for sending. First impression is I don't like it at all. Exclamation point. Let me get this to legal to get their thoughts, and I'll call you this afternoon. What are you guys, Glencore, thinking? And then you responded to that?
Yes.
And you said we weren't shipping WTL this month or next anyway, as they said they wouldn't be ready until June or July. We think that this is just a short-term workaround from what they have said outside of the email, so they don't have to file with FERC. What did you mean by short-term workaround?
That they were trying to buy a month or two to get to June, and April and May not offering that service.
And then he responds to you that same day. I think that's right. I talked to them this morning. Their problem is that they don't have much WTL coming in at Wink Orla, and the batches would be so small they thought it might be difficult to do. I know they finishing construction on a connection with Oryx at Crane that will provide them with significant WTL. My guess is once that is complete, they'll start batching WTL, estimated to be June 1. They're also making connection to Lotus at Crane. Once Lotus finishes that line from Midland to Crane, November 2020, more WTL from that source. You see that?
Yes.
So what was your understanding as to whether this was a temporary issue or a permanent issue with respect to Epic?
This was a temporary issue.
Did ARM or Glencore decide to take any action as a result of this email from Epic?
No, we did not. We obviously brought this to Mike's attention to let him know that we wanted answers around it. But once again, with a line of sight on when it would come back up, we were okay with it.
All right. Once the contract commenced on April 1, 2020, we've talked about the process for acquiring and nominating crude for shipment on the pipeline and loading at the dock. I don't think we all need much reminding, but what was going on in the world at this time?
This was at the height of the COVID pandemic.
And I know that, or we all know that a notice of breach was sent to Medallion on October 5, 2020. So that would be 6 months after the commencement date. How could you describe generally how things were going between April 1 as COVID hits and leading up to October of 2020?
Yeah, so April and May of June of that year, it was, we went into lockdown, the world went to lockdown. We were worried about the safety of our employees. We were worried, about maintaining our base level of business. The crude oil market, the worst it got was in June. Crude oil actually turned negative, and producers were shutting in. People were taking their drilling plans down. And it was really just getting back to a base level of business, April, May, and June, July. By the time we got to July, August, the world had begun to stabilize and we were looking at opportunities again. As we kind of came out of that, we weren't out of it, but we had gotten our arms around our businesses and we were looking at opportunities again.
So we talked about the original thesis of entering into these contracts with Medallion was to get WTL one of the primary reasons was to get WTL and ship it to Corpus Christi and then to international markets. Were you able to execute on that thesis in the first couple of months of the arrangement?
No, we were not.
Did there come a time when you started focusing on executing that thesis?
In August, when we got our feedback on the ground, we definitely started looking at that again. Salt Creek and Arm Midstream being the operator of Salt Creek, they in July of 20, they were no longer the operator of Salt Creek, and that ended the AMI that we had with Salt Creek. So it opened up AEM to have the ability to talk to all the Salt Creek customers and pursue additional business.
Was that good or bad for AEM?
It was very good for AEM because we were not able to go after those customers, and now the customer base that we could go after opened back up.
During the April to October timeframe in 2020, were you and Glencore attempting to source and ship WTL?
We were being told that WTL was not available. So we were not accumulating WTL for the transport capacity. AEM itself had contracts of WTL in the area, but we were not committing them under what is called in the master crude agreement a covered trade because we could not ship that.
I think you said WTL was not available. Were you talking about actual crude available in the market, or were you talking about capacity on the pipeline?
Capacity on the pipeline.
Did you have any communication with Epic or Medallion during this time period about whether they were going to ship WTL? And if so, when?
Glencore and AEM were consistently talking to Mike Lassman, and each month we would request or talk about WTL, and it was always 1 or 2 months away. So every time we brought it up, April it's in June, and August it's November, and so we were still it's a 5-year term. We were still interested in this deal, but it was always several months away.
Would it have made sense to acquire and then nominate on the pipeline WTL when Epic was telling you they wouldn't ship it?
No, they told us they could not ship it, and so we had jobs to do. We had real business to run, and buying WTL to have it rejected and then have to sell in the spot market would make no sense for us.
And just for housekeeping, we offered plaintiff's exhibit 77, and it's okay. I'd offer plaintiff's exhibit 77, which was the April 3, 2020 letter or email from Epic saying they weren't going to ship WTL.
Any objection?
Objection.
Plaintiff 77 is admitted.
All right. All right, let's look at plaintiff's exhibit 96. And can you identify this as an email from Hunter McDonald at Glencore to you and others at ARM and Glencore?
Yes.
And what's this email about?
This is a summary from Hunter McDonald at Glencore of the weekly call that the operations team would have each week regarding the Medallion capacity.
And when you talk about the operations team, there was a weekly call between ARM and Glencore?
Glencore, correct.
All right. And down below on the first page, it talks about issues with Epic.
Yes.
And the second big bullet point says optionality for WTL would be good, worth exploring further. Epic has issues with minimum operational storage requirements for WTL. Medallion contracts allowed WTL, while Epic contract does not. WTL purchases would likely be term deals. Need to figure out how we'd sell volumes on months when WTL is less favorable. You see that?
Yes.
So this is in August, early August of 2020. Why was WTL becoming a focus at this time?
We were hoping or believing that the capability to ship it was coming soon. I think at this time we were being told maybe November, and Glencore and us, AEM, were preparing for that, and Glencore saw value of WTL in the international market.
All right. Now, also in August of 2020, I guess we saw in that presentation we looked at earlier from Epic that they anticipated building the Suezmax terminal by Q3 or Q4 of 2020. By August of 2020, was there any indication that the terminal would be completed within that time frame?
No. Well, they would tell us that it was always several months away.
And was it a consistent several months away, or was it a moving target?
As a moving target.
As you were getting these moving targets, both on shipment of WTL and completion of the Suezmax terminal, how were you guys reacting to that? What was your reaction?
Yeah, at this point, per his issues with Epic email here in this time frame, we were starting to get concerned that what we were paying for, the service we were paying for, were not being delivered.
All right. Your Honor, I'd offer Plaintiff's Exhibit 96.
Any objection to Plaintiff 96? Thanks. I'm sorry, what'd you say?
No objection, Your Honor.
Plaintiff 96 is admitted.
All right, let's look at Plaintiff's Exhibit 208. And can you tell, this is an email, can you identify this as an email from Mr. Sarman to Guy Freshwater at Glencore and Hunter McDonald, you and Ben Beckham, Dave Cook, and Gabe Newley?
Yes.
And this is 4 days after that memo or that email we just looked at about your, where y'all are talking about WTL.
Yes.
And it says, gentlemen, please see attached document outlining the Medallion and AEM agreement broken out by section to further clarify points of demurrage, WTL, nominations, and additional rights. You see that?
Yes.
And then what follows, we don't have to go through it in detail, but there's an analysis of the contract and the issues you were dealing with WTL and the terminal and other issues.
Yes.
What precipitated the preparation of this document?
Per the last email from Glencore, we were not getting the services that we were paying for. And at this point, we were outlining what our services were, how outside legal viewed them, and what could be done, make sure we understood our rights.
What did you guys decide to do after reviewing and analyzing all this information?
Ultimately, in October, when things had not improved, we sent the notice of breach to Medallion.
And let's look at Plaintiff's Exhibit 111. Is that the notice of breach?
Yes.
And it's a letter dated October 5, 2020 to Mr. Lassman at Medallion, and you sent it to him by cover email?
Yes,
And what was the purpose of this?
to notify them of the services, the breach of the services we were not receiving.
Were you trying to terminate the contract at this point?
No, we were not.
What did you hope would be the outcome of sending this letter to Medallion?
The Medallion would be responsive, and we would receive the services we were paying for.
Now it says, as discussed, in your cover email, it says, Mike, as discussed, please find attached our letter regarding Epic Pipeline and Terminal. Did you discuss this with Mr. Lastman before you sent it?
Yes, I called him before we sent it, wanted to give him the courtesy, and let him know of what we were sending and why we were sending it.
All right, let's look at Plaintiff's Exhibit 113. Is this a series of emails between you and Guy Freshwater at Glencore on the day that the letter was sent to Medallion?
Yes,
And you wrote in the middle of that page under external sender highlighted in orange. Thank you, guys. Spoke with Mike on the phone today. Would that have been your call before you sent the letter?
yes,
I spoke with Mike on the phone today, and he said he would likely want to have a discussion once he has read through the documents, if he had any questions, et cetera. Obviously, you will be needed for that. The call was well received. He appreciated the notice, and they reiterated that they are incentivized to ensure that what they are contracted for is being met. See that?
yes.
Did that give you any comfort?
Yes, it felt like that the letter would be received and we'd be working towards a resolution.
And I'm okay. We would offer Plaintiff's Exhibit 113.
Any objection to plaintiff 113?
No objection, Your Honor.
Plaintiff 113 is admitted.
And I would also offer Plaintiff's Exhibit 208, which was the analysis of breaches that was prepared on, I believe it was August 7, 2020.
That's plaintiff 208.
Yes, sir.
Any objection?
No objection, Your Honor.
Plaintiff 208 is admitted.
All right. So you sent the notice of breach on October 5, 2020. Take a look at Plaintiff's Exhibit 117. Tell us what this is.
This is the Medallion response to that letter.
All right. He asked you for information in this letter, right?
Yes,
He said, he asked you to provide Medallion with any invoices that you may have received from Epic, including any storage fees associated with deliveries in excess of actual marine loading capacity. What was your reaction to this request for information?
Glencore was a little confused as the contract was with Medallion.
Did you view this particular request as a good faith request?
No.
Why not?
This seemed to be the beginning of, we're not in this together to fix it, but we are now requesting non beneficial to discussion questions.
So, was invoicing under the agreements done by Medallion to Glencore and ARM or by Epic to Glencore and ARM?
This is Medallion. Our contract was with Medallion.
So would Medallion already know exactly what pump over fees and demurrage were being charged?
We would assume, yes.
Next, he asked that you provide any documentation indicating that customer has attempted to nominate shipments of WTL or documentation evidencing Epic's rejection of any attempted shipments. Did you view that as a good faith request?
No, we did not. It was them that was telling us every month that we could not non-WTL or we could not non-Suezmax.
Did ARM or Glencore send any information in response to the request?
I do believe in time Glencore sent some of the demurrage, et cetera.
Overall, how did you interpret how Medallion was responding to you and Glencore in this letter?
That we were no longer working towards a resolution, or we feared that we were no longer working towards a resolution.
Now, 3 weeks later, if we could look at defendants exhibit 11. What is this document?
This is a issued October 30th Epic Crude Pipeline tariff.
And if we look at the pages marked Medallion 2388. of 35. Sorry. We see the product specifications again.
Yes,
And is Common Stream 1 and Common Stream 2, do they continue to be in the actual specifications that appear in the tariff?
yes,
And there's if we look under Common Stream 2, that column on the left, it says Common Stream product shipped from groups 1 to 3, and then there's an N and an asterisk. Do you see that?
yes.
And if we look at the next page, we see the N and the asterisk in the middle of the page, and it says, due to prevailing operating conditions, carrier does not currently offer service under this common stream.
Yes.
Do you have any reason to believe that this change relates to the complaints that, or the notice of breach that ARM and Glencore sent?
Glencore and AM felt that this was suspicious timing.
Did Medallion ever bring this change to your attention?
No, they did not.
Did Medallion, to your knowledge, ever challenge this?
To my knowledge, no.
Did ARM or Glencore have any direct contractual relationship with Epic at this time?
No, we did not.
Who had the direct contractual relationship with Epic?
Medallion.
Regardless of this note, did Epic, to your knowledge, ever remove the specification for Common Stream 2 from its tariff?
No, they did not.
All right, if we can look at Plaintiff's Exhibit 131. Whoops. Got the wrong exhibit number. Hold on a second. I'm sorry, I was looking at Defendant's Exhibit 131. Let's look at Plaintiff's Exhibit 131. What is Plaintiff's Exhibit 131?
This is a letter from Medallion to Glencore and AM related to the service.
And if we look at the attached letter from Medallion, it's enclosing and attaching a letter that they received from Epic. Keep going. Next page is a letter from Medallion. And then go to the next page. We see this letter from Epic, right?
Yes.
And on the second page of this letter, Epic addresses down at the bottom of the page the notice that was received by Medallion from Glencore and ARM that Epic Crude Terminal is violating the TSA because it is not offering a firm loading vessel with the capacity of 1 million barrels of crude petroleum. Do you see that?
Yes.
And they set out here their argument on why that's not a violation, right?
Yes.
What was the reaction to that argument within the ARM Glencore JV?
Yeah, so this is the first time we had heard that argument, and we view that as a fairly ridiculous argument, to take it to the extreme. If they could offer us up to not more than 1 million, to take it to the extreme, they could offer us a 1 barrel loading, if in that example.
And if we look on the next page, in the middle of the page, it addresses the failure to deliver WTL, right?
Yes.
And they just reiterate that they're not shipping WTL at this time.
Correct.
Your Honor, I don't know if you can hear, but we're having quite a storm here in Houston.
We have a minor one here in Dallas too.
Okay, hopefully it's not interfering with the audio.
I just heard a little bit of a boom. I was hoping you were okay.
Yeah, we're surviving. So let's look at Plaintiff's Exhibit 137. And is this an exchange of emails between you and Glencore after receiving this response from Medallion and Epic?
Yes, it is.
And you wrote, please find below our legal write-up in response to Epic. We believe they are in multiple breaches and it is likely time to move more aggressively, especially based on the ridiculous letter they provided. And you wrote that.
Yes.
And Mr. Freshwater at Glencore responded, agreed. I haven't managed to read the letter yet, but no, they dismissed our concerns out of hand. Personally, I think it's an appalling approach. I told Mike it was time to turn up the heat, although that may mean on them also. And Mike would be Mike Lastman at Medallion.
Yes.
And the notion was to turn up the heat on Epic.
Medallion and Epic, yes.
Medallion and Epic. So this is both you and Glencore that are addressing or raising these issues with Medallion and Epic at this time, right?
Yes.
I'd like to look at a slide that Mr. Patterson put up during opening. And before I touch on this, I would offer Plaintiff's Exhibit 137, which is the email exchange we were just discussing.
Plaintiff 137. Okay. Any objection to plaintiff 137?
No objection, Your Honor.
Plaintiff 137 is admitted.
All right. Now, Mr. Patterson spent a great deal of time on this on opening and was suggesting that the reason that you guys were raising these issues with Medallion and Epic was because you were underwater and suffering losses on the demand charges, the transportation fees that you were required to pay under this agreement. Did you hear all that? Were you listening in or?
I was not.
Okay. Well, take my word for it that that's what he said. Was Glencore exposed to any of these losses?
No, they were not.
Why not?
Per our master crude oil agreement, AEM was paying the $1.50.
Can you think of any reason why Glencore would want to get out of the agreements because of those losses that were being suffered only by ARM?
No.
Why did ARM and Glencore send the notice of breach to Medallion?
We wanted to receive the services that we were paying for, which was the WTL and the 1 million barrel loading vessel. That was attractive to Glencore, and that's what they wanted as well as us.
All right, so we're now talking about November of 2020. And you've had this exchange with Medallion and Epic. and it was 30 days after you sent the notice of breach on October 5. Did you all terminate at that time?
No, we did not.
Why not? Why did you wait?
We were still being, I guess at this point, we would say strung along, that the dock and the WTL was on its way. As we've discussed, this was a 5-year deal. We still wanted this to survive, and we still wanted to move forward if we were able to get the services that we were paying for.
Now, I know that at some point after this exchange of emails, there was a nomination of WTL on the pipeline and a nomination on the terminal for a Suezmax type load. Why were those sent?
That was ultimately a legal discussion, and they were a bit frivolous. We had already been told that they wouldn't be accepted, but we sent those anyway.
All right. Now, if we could look at Exhibit 162, Plaintiff's Exhibit 162. And I believe this has been pre-admitted. I'm sorry, I'm looking at the wrong. Where's the accommodations letter? Oh, this is it. All right. Can you tell us what this exhibit is?
This was an email from Mike Glassman on February 9th with Epic updates.
Plaintiff 162 has not been pre-admitted. Oh, wait a minute, maybe it has. Sorry. Go ahead.
I believe a plaintiff's version of this document.
No, Plaintiff's 162 has not been admitted.
Well, we would offer it. I think it's a duplicate of a defense exhibit.
Any
No,
objection, Plaintiff's 162?
No objection, Your Honor.
Plaintiff 162 is admitted.
All right, so this is Mike Glassman to you and to Guy Freshwater at Glencore, and it's dated February 9, 2021. And I believe Mr. Patterson showed the court this email during opening, and it involved a one-time offer of WTL batching services on April 1, 2021 of 3,333 barrels per day. And it also offered some accommodation with respect to the Suezmax. What did you understand Medallion was offering here?
Medallion was offering a ability to blend some WTL into their regular stream on point 1, that 3,333 a day. They were not offering to give us back a WTL barrel on the dock, which was the service we were paid for. And then on point 2, they are offering a solution to go to the Pin Oak dock, which was already what Glencore was doing. This infuriated Guy, as Guy was already moving barrels to Pin Oak. So they gave him a solution that was already what Guy was doing himself. Guy did not want a Pin Oak loading. He struck this deal as the Epic dock, and that's what he wanted.
What did you conclude about Medallion's and Epic's willing to perform the obligations with respect to the WTL and Suezmax terminal at this point in February of 2021?
At this point, and per this document, they said it says that they will never be able to load more than 750,000. And on point 1, that wasn't even a solution to ship WTL. They were just offering to take a few into their stream. So this indication was that they were not going to provide that service.
All right, let's look at Plaintiff's Exhibit 176. And this is a termination agreement dated March 19, 2021.
Yes.
And I believe this has been pre-admitted. Someone correct me if I'm wrong over on this side. Oh, it's not. Okay.
It is not pre-admitted.
What is this document? Can you identify it?
This is the termination agreement of the Transportation Services Agreement, March 19, 2021.
And who is this with?
This is I believe this is the AEM and Medallion in Glencore. This is AEM in Glencore.
All right. What happened to your relationship with Glencore in March of 2021?
It was terminated.
And who terminated it?
Glencore.
What was your understanding of why Glencore was terminating the agreement?
They were not getting what they signed up for, and it was time for them to move on.
Medallion has argued that Glencore terminated because of an issue with shortfalls in arms supply sourcing of crude. Do you recall any issues involving shortfalls?
Yes, in October and November of 2020, we were delivering them a certain amount of volume. In each of those months, our deliveries came up short of the nominated volume.
Was that a big issue between you and Glencore?
It was not. We gave them makeup. So what we did not give them in October, we gave them in November at the October price. And what we did not give them in November, we gave them in December at the November price. Glencore faced no losses.
Do you have any reason to believe that Glencore terminated the relationship in March of 2020 or that termination had anything to do with shortfall issues months before?
I do not.
Okay, we talked about ARM's initial business strategy and entering into this contract and harvesting the optionality from the ability to ship WTL from the Permian Basin to Corpus to international markets. How did Medallion and Epic's position that they would never ship WTL or that they would not ship WTL and never have a Suezmax capable terminal impact that strategy?
Yeah, let us know that we were never going to be able to execute that strategy.
Could you have pursued any strategy to export to international markets without a partner like Glencore?
No, we could not.
Did you have any prospect of finding another partner like Glencore when Medallion was refusing to perform the contract?
No.
I believe Defendant's Exhibit 32 is the notice of termination from ARM to Medallion. We could look at that. Why did you guys send the notice of termination at this time?
We were told that we were never going to receive the services that we paid for, and it was time to terminate.
Did ARM terminate the contract because it had been unprofitable to ARM?
No, we did not. It was a 5-year agreement, and we wanted the services we were paying for.
Are there other contracts where you have periods of losses followed by, profits on the contract?
Yes, these are term agreements, and over a long duration of agreement, you'll have good times and you'll have bad times. One of the examples is the intensity capacity that we have. We were losing hundreds of thousands a month, 400,000 a month to be exact, for years. And we, in a winter storm, we were able to make the entirety of that contract plus good dollars in 2 months. And that's the way these deals work.
Have you terminated any contracts because they're unprofitable?
No, we have not.
Now, we heard an opening, and I can take you through it, but there were prepayments that were made by ARM under the 2 agreements, right?
Yes.
And I believe the prepayment on the transportation agreement was $12,193,000 paid on August 19, 2019. And the prepayment on the terminal agreement was actually made by Glencore and reimbursed by you guys?
Correct.
And if we can look at Plaintiff's Exhibit 45. Is this a document indicating that the 12 million plus on the prepayments on the transportation?
Can I ask, wait, so this is being broadcast on YouTube. I can't tell if those are routing numbers or things like that. Do you want me to take this off of YouTube? I didn't know you guys were going to be putting in bank documents, or it looks like it's mostly redacted.
I, yeah, I've got PX 45 and 74 on the prepayments, and I also have PX 56 on the $16,910,000 letter of credit.
I'm just asking, do you want me to take this off of YouTube because there's might be confidential information on there?
Yes, and what I'm suggesting is we just go ahead and admit the exhibits because they, without publishing them at this time.
Okay, what were they?
45, 56, and 74.
All plaintiffs?
All plaintiffs, yes, sir.
45, 56, and 74. Any objection?
No objection, Your Honor.
So just give me 1 second. 45 is admitted. 64, 64 is that looks like an email thread for plaintiff.
No, 56 and 74. 45, 56, and 74.
Okay. 45, 56, and 74 are all admitted without objection.
And then once performance commenced, did Glencore ever fail to pay any demand charges to Medallion during the period the contract was in effect?
No, they did not.
And did AEM fully reimburse Glencore for all demand charges?
Yes, they did.
And again, Your Honor, I've got a number of documents. Maybe we can handle it at a break, but I've got PX 90, 100, 102, 103.
Wait, are you offering these and are they objected to?
Yeah, I'm offering these. They're just the reimbursements, documents reflecting the reimbursements by ARM to Glencore.
All right, any objection to 90?
No objection, Your Honor.
90 is admitted. What's the next one?
100,
Any objection to 100?
No objection, Your Honor.
next
100 is admitted.
102,
No
Any
objection,
objection?
Your Honor.
102 is admitted. 100 and 102 are admitted.
103,
Any objection to
No
103?
objection, Your Honor.
103 is admitted.
109,
Any objection to 109?
No objection, Your Honor.
109 is admitted.
125,
Any objection to 125?
No objection, Your Honor.
125 is admitted.
it's got a couple more. 138,
Any objection to 138?
No objection, Your Honor.
138 is admitted.
148,
Any objection to 148?
No objection, Your Honor.
148 is admitted.
160,
Any objection to 160?
No objection, Your Honor.
160 is
170.
admitted.
I'm sorry, Your Honor. 171,
Any objection to 171?
No objection, Your Honor.
171 is admitted.
and lastly, 182.
Any objection to 182?
No objection, Your Honor.
Give me 1 second. 182 is admitted.
All right, at the time of
What
the
was the one before 182? I want to make sure I marked it right.
171, Your Honor.
Okay, yeah, got it.
Okay. At the time you terminated the contract, were any payments owed under the contracts?
No.
Okay, let's, just a couple of final matters. If we could go back to the the transportation services agreement, which is plaintiff's exhibit 1. And if we could look at section 6.04 on page 11, page numbered 11. And this deals with the right to terminate the contract based on a carrier default. And if we look down at B, it talks about the cure period, 604B. Let's get that up. 604B talks about the cure period, and then it says on the next page, there's a sentence that begins in addition. Yes, the next page, page number 12. All right, the next page, page number 12. All right, there's a sentence in the middle of that paragraph at the top of the page. It says, in addition, shipper, that'd be ARM, right?
Yes.
Shall be entitled to all rights and remedies provided for in this agreement, the tariff, or under applicable law to recover damages due to a carrier default, and carrier shall immediately return all prepayment deposit and credit support provided by shipper without withholding, set off, or reduction. Do you see that?
Yes.
Did Medallion immediately return the prepayment deposit or the credit support?
No, they did not.
Have they kept the prepayment?
Yes.
Did they call on the letter of credit?
Yes.
All right, let's look at the terminal services agreement, which is plaintiff's exhibit 2. And let's look at section 14.13 on page 23, page numbered 23. All right, do you see that paragraph D? It's talking about termination. And it says, following expiration or termination of this agreement, Medallion shall return all remaining prepayment deposit and credit support to customer. Do you see that?
Yes.
Did Medallion do that?
No.
What impact has it had on ARM that Medallion has kept this money, this prepayment, and drew down on the letter of credit?
The amount of dollars that they were holding has not allowed us to go out and find a replacement service for this thesis that we had in place. And we won't be able to until we get those dollars back.
Pass the witness.
Any cross? I can't hear you if you're crossing. I can't hear you. Can you hear him? Is there any cross?
He may be going to his podium.
Okay.
Yeah, Your Honor, the microphone died at just when it was my turn.
Okay.
So yes, I do have cross. So Mr. Wishoff, ARM, let me know when you're ready.
So, I'm sorry, they put the box next to me. I think you'll have them up on the screen though, right?
Yes, we'll put them up on the screen for you. Mr. Wishoff, ARM managed a company called Salt Creek Midstream, right?
ARM Midstream managed Salt Creek Midstream, was the operator. Aries was the controlling 97% in that entity.
Salt Creek, under the operation of ARM, entered into an agreement with EPIC for capacity on EPIC's crude oil pipeline back in 2018, right?
I believe that to be true.
The agreement between Salt Creek and ARM was in place long before the July 2019 agreements between ARM and Medallion, right?
I'm sorry, could you say that again?
The agreement between Salt Creek, which was being operated by ARM, and Epic was in place long before the July 2019 agreements between ARM and Medallion, right?
I believe that to be true.
You had a direct chain of communications with the folks over at Epic about what was happening with the pipeline and the docks, right?
There would have been communication, yes.
One of the Epic executives ARM dealt with was Thomas Simpson, right?
Salt Creek dealt with?
You, Scott Wishoff. One of the executives that you, Scott Wishoff, dealt with at Epic was Thomas Simpson, right?
I talked to Tommy, yes.
Yes. You knew him as Tommy, right?
Yes.
You talked with Tommy Simpson at Epic several times in 2018 about Epic's dock capacity, right?
I believe that to be true.
Medallion was not on your calls with Tommy Simpson about dock capacity, right?
Not at that time, no.
You discussed with Tommy Simpson of Epic the capabilities of Epic's interstate grain terminal, which would eventually become the initial terminal, right?
I believe that to be true.
You discussed with Tommy Simpson of Epic the size of ships that would be able to load at the interstate grain terminal, right?
I believe that to be true.
You got information directly from Epic about when the new terminal would be available, right?
In 2018,
Yes.
they were offering out to the marketplace their project, yes.
At that time in 2018, ARM, as the operator of Salt Creek, was evaluating several different terminals in Corpus Christi to export crude oil that Salt Creek shipped to Corpus Christi using the Epic pipeline, right?
Salt Creek was, yes.
Plaintiff's Arms Counsel showed you Defendant's Exhibit 205. Why don't we take a look at that briefly? You recall looking at this document?
Yes.
This document is from August 2018, right?
Yes.
This document is addressed to you, among others. The folks who are listed there are ARM people at the top, right?
Yes.
And this was one of these documents that had attached presentations and information from Epic, right?
Yes.
For example, we looked at the fact that there was a form tariff attached to Defendant's Exhibit 205, right?
Yes.
All right. This was Epic communicating directly to ARM, right?
This was Epic to Taylor Tipton, I believe.
And you, right?
Was that directly to me?
We can go back to the first page and see if you're on there.
I think Dustin.
Right. They said.
That's from my boss, Taylor Tipton. He was
Okay.
forwarding.
So yeah, they were. So I didn't mean to interrupt you, sir. Go ahead.
That was my boss was forwarding that on.
Okay. This was Epic communicating directly to Taylor Tipton, your boss at Epic, and he forwarded it to you and other people at ARM, right?
Yes.
Staying around that time, back in the summer of 2018, let's look at Defendant's Exhibit 44. Defendant's Exhibit 44, this is July 2018, so this is about a year before the agreements between ARM and Medallion, right?
Yes.
This is an email chain that was produced by ARM in this case, right?
I believe so, yes.
This is a series of emails that you had with Tommy Simpson of Epic, right?
Yes.
If you go to let's go to the second page. On July 19, 2018, you write to Tommy Simpson, Tommy, I hope all is going well and you are enjoying the summer. A lot of competitors are spreading incorrect information in the marketplace about our projects, ability to close, complete, operate, what have you. Do you guys have any material we could use to combat any of this? Do you see that?
Yes.
Salt Creek, the company that ARM was operating, was had as a majority owner a private equity company called Ares, right?
Yes.
Ares also had an ownership interest in Epic, right?
Yes.
In fact, the same people at Ares, such as Jesse Yanocha, were involved in supervising both the Salt Creek project and the Epic project at the same time, right?
I'm not sure of Jesse's complete roles, but he was involved in some of it.
That's why you were referring to our projects and asking for information from Mr. Simpson to rebut information that was out there in the market, right?
We were asking, what I was asking is, were they on, does he have materials that could combat any of the negative information in the market? Yes.
And in response, if we go to the first page, Mr. Simpson gives you some information, right?
Yes.
Among other things, Mr. Simpson tells you that SCM, that's an acronym for Salt Creek Midstream, right?
Yes.
Is about to execute an agreement to take capacity on Epic's pipeline, right?
Yes.
In 2018, you believe that it was, we can take that one down that we were looking at. In 2018, you believe that it was definitive that Epic would transport WTL on its crude oil pipeline, right?
In 2018, I believe, I don't necessarily remember the exact timeline, but there was discussion of the interim service and the full service at some point.
You believed that when full service began, Epic was going to transport WTL on its pipeline, right?
Yes, when full service began, it was being constructed to ship WTL, yes.
You believe that WTL service on Epic's pipeline was going to happen with full service because Epic told ARM that it was going to have a WTL stream, right?
I believe that's they were telling the marketplace that's what they were going to do.
Including ARM. ARM received that information from Epic, right?
We received their shipper meeting documents, et cetera, yes.
Yeah. ARM received Epic's marketing material that stated Epic would have a WTL stream on its pipeline, right?
Over time, yes.
When you wanted information about how Epic was going to manage quality streams, you asked Epic, right?
In 2018, yes.
Okay. ARM met with Epic to discuss how the WTL stream was going to be defined, whether the top end was going to be 48 degrees or 50 degrees, right?
I don't recall, but the meeting, but yes, there was a discussion on 48 versus 50, yes.
Right. Those discussions took place in 2019, right?
I don't recall, but the timeline sounds about right.
Right. Epic, strike that. ARM had direct discussions with Epic about how Epic was going to define its WTL stream after ARM had contracted with Medallion, right?
State that again, please.
ARM had discussions with Epic about how Epic was going to define its WTL stream after ARM had contracted with Medallion, right?
I don't recall if it was before or after.
As an example, we can look at the defendant's exhibit 163. By the way, before we move to 163, I would like to move admission of the email chain between you and Mr. Simpson, which was, it's up to me to keep track of that, defendant's exhibit 44.
No objection.
Defendants 44 is admitted.
Let's look at defendant's exhibit 163. Do you see defendant's exhibit 163?
Yes.
Okay. Defendant's exhibit 163 is an email chain between Epic and Shannon Flowers of ARM, right?
Yes.
Shannon Flowers of ARM was one of your colleagues, right?
Yes.
This is October 2019, about 3 months after ARM entered into the agreements with Medallion, right?
Yes.
It is about 6 months before commencement of services on the Epic pipeline, right?
Yes.
If we look at Mr. Flowers' email toward the bottom, he's asking Jeff at Epic about a couple of items relating to the quality of crude oil that will be flowed on Epic's pipeline, right?
Yes.
Including, he asked about updating the gravity limit on the WTL stream from 48 to 50, right?
Yes.
ARM continued to have a direct line of communication with Epic about the WTL stream after it contracted with Medallion, right?
ARM employees did talk to Epic employees.
I move admission of defendant's exhibit 46.
Any
No
objection? Defendants 46.
I'm sorry, I was wrong. 163. I move admission of 163.
Any objection?
No, Your Honor.
Defendant 163 is admitted.
Arms counsel, okay, we can take that one down. Arms counsel had shown you a draft term sheet that Mr. Lastman sent to you. Do you recall that?
Yes.
You understood that there would be contractual contracts that were prepared after that, right?
From the initial draft to Taylor Tipton, yes.
You understood that the contracts would be the governing documents, right?
Correct.
When Arms counsel asked you this morning who was involved in the negotiation, you answered Josh Sarman. Who was Josh Sarman?
Josh Sarman was a trader for AEM.
When Arms counsel asked you who was involved in the negotiation, you didn't mention any lawyers, right?
I believe what I said was on the commercial side, it was Josh and myself.
Okay. ARM had lawyers to be involved in the negotiation of the contracts with Medallion, right?
Yes, and so did Medallion. I don't think I mentioned that either.
Right. ARM had in-house counsel Gabe Nwuli and Dave Cook, right?
Yes.
ARM had lawyers from the international law firm of Evershed Sutherland named Ram Sankara and Kyle Wamstead, correct?
Yes.
All of these lawyers had deep experience with energy industry transactions, right?
I believe so. Yes.
Did you read the contracts with Medallion before they were executed?
Yes.
Let's look at Defendant's Exhibit 215. Defendant's Exhibit 215 is an email from Veronica Lewand at Epic to a number of people on May 16, 2019. See that?
Yes.
This document was produced by ARM, right? If you look at the bottom, it's an ARM Bates number, right?
Okay. Yes.
This document from Veronica Lewin at Epic, and we talked a little bit about her earlier today, is about a month and a half before the agreements between ARM and Medallion, right?
Yes.
Epic sent this document to Taylor Tipton, the president of ARM, right?
Yes.
Epic sent this document to Shannon Flowers, who we talked about a little bit, right? An ARM employee.
Yes.
Epic sent this document to Dave Cook, who I just mentioned, the general counsel of ARM, right?
Yes.
And Epic sent this document to you, right?
Yes.
You see anyone from Medallion on the recipient list for this document?
I do not.
If we look at the page that is base numbered AEM 11238, this is the attached presentation. In this document, Epic told you that the IGC dock is dredged today to the common 45-foot depth similar to other inner harbor docks. Do you see that?
Yes.
And the IGC dock is the interstate grain dock that became the initial dock, right?
Yes.
Epic sent you this information in May of 2019, right?
Yes.
If we look at the bullet point above that, Epic also told you that the interstate grain dock will be Aframax capable with dimensions of 820 feet by 144 feet, right?
Yes.
If we go to page AEM 11246, we see on this page that Epic told you that it planned to have a Permian Common Stream 2 WTI light, right?
Yes.
Okay. I would like to move admission if it is not already admitted. Do we know if this? Okay, so I'd like to move admission of the Defendant's Exhibit 215.
Defendants
Objection, Your Honor.
All right, defendants 215 is admitted.
Very good, we can take that one down. And now, Mr. Wishoff, you believed that the new terminal would be built out at Ingleside, the outer harbor, not the inner harbor of Corpus Christi, right?
No, they were going to have an initial terminal, a new terminal, and then at the time they were talking about a third option at Harbor Island.
Right, but you believed that the new terminal was going to be out at Ingleside, right?
Maybe in 18, when they were talking about that, but they did not ever build that facility.
Right, so after 2018, you realized that the new terminal was going to be an inner harbor facility, right?
It was at the Interstate Grain Terminal, yes.
Well, you knew that the Interstate Grain Terminal was going to be the initial terminal, right?
Yes.
And you knew that, the contract, the terminal services agreement says that the new terminal is going to be adjacent to the initial terminal, right?
Right.
Right. But you believed as of April 2021 that the new terminal was going to be out there in the outer harbor at Ingleside where the depth is deeper, right?
No, that's not correct.
You testified in a temporary injunction hearing in this case, right at the beginning of the case, right?
Yes.
Right. And that temporary injunction hearing was in early April of 2021, correct?
Yes.
And the reason you were testifying was ARM was attempting to get an injunction against Medallion from drawing on ARM's letters of credit, right?
Yes.
Which the court denied, and then ARM subsequently drew on the letters of credit, right?
Medallion drew.
Medallion subsequently, yeah. Sorry about that. So it's your testimony that at the time that you testified, you believed that the Medallion was in breach because the new terminal, did you believe that the new terminal was going to be built in the inner harbor at that time?
Yes, we did. So we're conflating a little bit of the time frame here. So we're talking about 2018, which was before Medallion entered the picture. We then move into 19, and things have evolved. And then in 19, when we go down our path with Medallion, AEM's contract, which I am responsible for, is a contract with Medallion. And I am going to Medallion at that time for our legal agreements and what we're going to do with Medallion. We were being told that we will get a Suezmax in the interstate grain, which is the initial and new terminal. And we believe that to be true, and I believe that to be true.
If we look at your hearing testimony from the temporary injunction hearing, specifically at page 61, line 8, you recall testifying, right?
I do.
All right. Do you see that you testified, is Pin Oak Terminal acceptable or unacceptable, and why? You testified Pin Oak was denied by Glencore. You know Glencore had their reasons. Pin Oak is not a replacement for the new terminal that was to be constructed at Ingleside, which would have been a superior facility, which is why we wanted to operate there. This is in the Corpus Christi ship channel, and that is not what we were looking for when we signed this contract. Do you see that?
I do see that.
When you testified in early April 2021 at the conclusion of these contracts, you believed that the new terminal was supposed to be out at Ingleside, right?
I said Ingleside. I don't know. I don't see the new. Yeah, I do say the new terminal. Once upon a time, there was a terminal they were going to build at Ingleside. Yes.
You say you said it. Are you saying you just misspoke there?
I think there's some confusion on what is initial terminal, new terminal, and then the Harbor Island terminal.
Let's look at your testimony from page 62, lines 5 to 13. Do you see where you were asked the question, and why is that undesirable compared to Ingleside? And you said, Ingleside is under the Port of Corpus Christi's authority, but it is not on the Corpus Christi ship channel. It has superior location as it is outside of the channel. It will be dredged sooner. There are advantages to being out there, the turnaround, the loading at night, etc. So when we were signing up for a contract, we were not looking to sign a contract on the Corpus Christi ship channel. Do you see that?
Yes.
That was, and in fact, in your answer there, you said that Ingleside will be dredged sooner. That was your belief as well, right?
Ingleside would be dredged sooner, yes.
Let's go to your transcript at page 94, lines 8 to 14. Do you see the question that was posed to you? Why was it important for you guys to be able to access the new terminal at Ingleside? This is a question from Arm's lawyer. Your answer was the new terminal had the superior location, had the superior size. Dredging had occurred first, had the superior loading rates. It had nighttime loading, everything that we wanted. And we wanted to avoid the Corpus Christi ship channel. You see that?
Yes.
It was absolutely your belief as of April 2021 that the new terminal was supposed to be out at the Ingleside and not in the inner harbor of Corpus Christi, right?
I think there's some confusion on new terminal versus the Harbor Island terminal. But I obviously think there was a terminal at Ingleside, yes.
You knew that an inner harbor, a terminal in the inner harbor could not handle full loading of 1 million barrels in a ship, right?
No, when you discuss Ingleside, the intriguing thing about Ingleside and the dredging would be for VLCCs. So the very
but you
large.
knew that the. I'm sorry. Go ahead. I didn't mean to interrupt you, sir.
Yeah. So Ingleside would have been to load the VLCCs.
Right. But you knew that an inner harbor channel terminal could not handle the full loading of 1 million barrel ship, smaller than a VLCC, right?
No, there are and there were Suezmaxes being loaded in the Corpus Christi channel.
Let's look at the transcript from page 81, lines 16 through 21. You were asked the question, and the channel at Corpus Christi cannot handle loading 1 million barrels on a ship, at least at this time, can it? And your answer was no. That's why you guys are in default, because you were supposed to build a new terminal over in Ingleside, and that's where the default has come in, right?
I said that, yes.
Right. You knew that an inner harbor terminal could not handle loading 1 million barrels on a ship, right?
I knew that Suezmaxes were being loaded in the inner harbor or on the Corpus Christi ship channel. Maybe not quite up to 1 million barrels.
You can take that down. You were interested in the timing for the opening of the new terminal. You testified about asking questions about that. Remember that?
Yes.
You continue to be interested in the timing for the opening of the new terminal after ARM executed its agreements with Medallion, right?
Yes.
If we look at Plaintiff's Exhibit 250, Plaintiff's Exhibit 250. Plaintiff's Exhibit 250 is an EPIC press release dated August 19, 2019. Do you see that?
Yes.
It's the same summer of 2019 when the agreements were entered into between ARM and Medallion, right?
We signed in July of 19.
EPIC publicly stated in a press release on August 19, 2019, that the first EPIC crude export dock is scheduled to be in service before the end of the year and will be capable of loading Aframax-sized vessels. Do you see that?
Yes.
This was not a surprise to you. You already knew that the initial terminal would be capable only of loading Aframax-sized vessels, right?
This was on their interim service in 2019.
EPIC also stated publicly in this press release in August 2019 that its second crude export dock is also under construction and has a targeted in-service date during the second quarter of 2020. Once the second dock is complete, EPIC will have the capability to load a Suezmax vessel from its waterborne terminal. Do you see that?
Yes.
This was information that was in an EPIC press release in August 2019 saying that the Suezmax capable terminal would be open in the second quarter of 2020, right?
Yes, that lines up with the June timeframe, I believe we were told.
Okay. Move admission of Plaintiff's Exhibit 250, Your Honor.
Any objection?
No objection, Your Honor.
Plaintiff 250 is admitted.
So we can take down Plaintiff 250. Shannon Flowers, you've testified about him a little bit. He's one of your colleagues at ARM, right?
Yes.
He attended meetings that EPIC held to explain its pipeline and terminal plans, right?
Yes.
Let's look at Defendant's Exhibit 41. You see that Shannon Flowers of ARM sent to you and Josh Sharman with a copy to Taylor Tipton, all ARM people, an email on November 20th, 2019.
Yes.
This is about 6 months before commencement of services under the agreements between Medallion and ARM, right?
Yes.
Mr. Flowers summarizes for you the biggest items from the EPIC shippers meeting, right?
Yes.
Mr. Flowers tells you that the initial dock was Aframax capable, loading at 20,000 barrels per hour, right?
Yes. This was 4 months after we signed our contract with Medallion.
Mr. Flowers also then says to you and to Mr. Sarman, with a copy to Mr. Tipton, that the expanded dock was to be ready in late third quarter of 2020 or fourth quarter of 2020 to be Suezmax capable at 40,000 barrels per hour. Do you see that?
Yes.
That is later than what we had seen in the press release from Epic that we just looked at from August of 2019. That's a later start date for the new terminal, right?
Yes, we signed our contract with Medallion in July, and the slippage has already started.
Right. And Epic was telling ARM and other shippers about that slippage as of November 2019, right?
Yes.
Medallion wasn't even at these Epic shipper meetings, right?
I do not know.
You see where Mr. Flowers says that the do you see, I'm sorry, there was some feedback. All right, do you see, Mr. Flowers, that Mr. Wishoff or Mr. Flowers says that the expanded dock would be Suezmax capable at 40,000 barrels per hour?
Yes.
Arms Council showed you a provision in the Terminal Services Agreement that referred to the loading rate of 40,000 barrels per hour. Do you recall that?
Yes.
Do you recall testifying that that was a Suezmax loading rate?
That was a rate that was associated with loading a Suezmax. Yes.
Right. And we see the line above, the initial dock, Aframax capable, loading at 20,000 barrels per hour. Do you see that?
Yes.
That loading rate of 20,000 barrels per hour is consistent with loading an Aframax, right?
You can load a Suezmax at 20,000 barrels per hour as well. There's just longer demurrage time.
It would take longer than 36 hours to do that, right?
Not 36, but somewhere in there.
If you were to fully load a Suezmax at 20,000 barrels per hour, how many hours would that be?
Yeah, you're right. It'd be longer than 36 hours.
It would take longer than 36 hours to load a Suezmax at 20,000 barrels per hour, right?
Right.
I move admission of Defendant's Exhibit 41.
Objection.
What exhibit was that again?
41, Your Honor.
Plaintiff or defendant?
Defendant 41.
41 is admitted.
All right, we can take down 41. Now let's look at Defendant's Exhibit 194. All right. Do you remember that we looked at Defendant's Exhibit 194 in connection with your questions that you answered from counsel for ARM, right?
Yes.
And he had asked about Veronica Lewand, in fact, and you testified about who she was. She was one of the people at Epic, right?
Yes.
Okay. And then we looked at some of the attachments to Defendant's Exhibit 194, right?
Yes.
To be clear, he asked you if this was April 1, 2019. This Exhibit 194 is November 20, 2019, right? Not April 1, 2020.
I don't recall if that was a different exhibit. I think there are several shipper meeting documents, but this is 11/20 of 219. This one is.
Right. This is 5 or 6 months before the commencement of services, right?
Yeah. Yes. 4 months after we signed our Medallion contract.
Right. This is the same day as the email that we just looked at from Mr. Flowers to you and others at ARM describing what had happened at the Epic Shippers meeting, right?
Yes.
Okay. This is another email that Ms. Lewand at Epic sent to a number of different people from ARM, right?
Yes.
We have Mr. Tipton, Mr. Flowers, Ms. Mitchell, Mr. Cook, Mr. Sarman, and you, Mr. Wishoff. You are all ARM folks directly on this email from Epic, right?
Yes.
Once again, you don't recognize any of the recipients of this email as being someone from Medallion, right?
Let's see. No.
And if we go to page 2107, AEM 2107, you see again that Epic is telling the shippers that the full service 40,000 barrels per hour is not going to come until the third or fourth quarter of 2020, right?
Commensurate with the Suezmax.
Right. You knew that date had slipped, right?
Yeah, once again, 4 months after we signed our contract, we are now aware that it is moving back.
You knew that date had slipped because Epic told you the date had slipped, right?
Their marketing materials, yes. Mike Glassman, I don't recall, may have told us the same.
You don't recall Mike Glassman discussing that with you around this time, right?
I don't remember, no.
Right. And once again, we see at 2110 that Epic is telling you that the interstate grain dock is dredged to the common 45-foot depth, similar to other inner harbor docks. You see that?
Yes.
Right. And we now know from looking at the terminal services agreement that the new terminal was going to be an inner harbor dock, not out at Ingleside, right? We already talked about that.
Yes, the initial terminal and new terminal are in Corpus Harbor.
Okay. Was 194 already admitted? I move admission of defendant's exhibit 194.
No objection.
That was defendants 194, correct?
Yes, Your Honor.
All right, defendants 194 is admitted.
I'll take that now. In December 2019, you and your colleague Josh Sharman of ARM and some folks from Glencore went down to Corpus Christi and got a tour from Tommy Simpson of Epic of the interstate grain terminal and the planned site for the new terminal, right?
Yes.
You could see that the planned site for the new terminal was right there on the inner harbor next to the interstate grain terminal, right?
Yes.
Medallion was not on that tour in December 2019, right?
No.
Tommy Simpson and Jeff Darrow of Epic, we saw an email with the name Jeff on it before. They explained to you and to the folks from Glencore Epic's plan for operating the dock, right?
They were our host for the meeting, yes.
Right. And as your host, they explained to you and to Glencore what Epic's plans were going to be for operating the dock, right?
Yes, they showed us the facility and how it was going to work.
Jeff Darrow of Epic explained to you on that tour that the Suez dock was not scheduled to be finished until November 2020, right?
I don't recall on that meeting. Maybe. I don't recall.
Okay. You and Glencore actually got to see Epic load its first ship at the initial terminal, right?
No, there was no loading when we were there.
Okay. Let's look at Defendant's Exhibit 89. This is an email that you sent to Mike Glassman on December 11th, 2019, and you describe having been down to Glencore yesterday in Corpus at the dock in Robstown. You see that?
Yes.
Then you say they got their first ship loaded and sent with no issues. You see that?
Yeah, we did not see it, but I think it had just occurred.
Right. You were there shortly after the first loading. Is that right?
I think that's correct.
Okay. Then you tell Mr. Lassman and Bo Dunn, who is an ARM person, right?
Yes.
You tell them that we're days away from getting our deal done, but perhaps not Friday. You see that?
Yes.
And the deal you're referring there to is the deal with Glencore, right?
In December of 19, yes.
Right. Glencore wanted to actually go down and look at the dock and look at where the new terminal was going to be before they signed the deal and took assignment of the agreements from ARM, right?
That is correct. They're the experts on the water, and we needed them to look at it, and they wanted to look at it as well.
Right. And having gone down and looked at it, they took assignment of the agreements, right?
Yes, they did.
I move admission of Defendant's Exhibit 89.
Any objection?
No objection, Your Honor.
Defendant 89 is admitted.
Um,
All right, let's do this. Yeah, let's go ahead and break for today. So let's kind of talk about where we are on this.